Hello everybody, my name is Kyle Burgis. I'm a senior employment lawyer with Minken Employment Lawyers, and today I want to take a couple moments to discuss with you the concept of frustration of contract and the question of whether it can be established in the circumstances of job loss caused by COVID-19. So the first question you may have is, what is frustration of contract? In a nutshell, because we only have a couple moments here, frustration of contract can occur when a contract of employment is at an end through no fault of either party, due to an unforeseen circumstance or event which renders the contract impossible to be performed as originally agreed upon. So why do we care about frustration of contract? You see, a frustration of contract can be established, and if that frustration of contract is in no way linked to an illness or injury being suffered by an employee, then the employment relationship is at an end, and the employee is not entitled to their statutory termination pay, statutory severance pay, or common law notice. Now the ultimate question: can job loss as a result of COVID-19 qualify as frustration of contract? The answer to that question as it currently stands is maybe. You see, the circumstances and facts of every case is extremely important, especially for frustration of contract. There may be numerous ways in which people have job loss caused by COVID-19 that may not be able to qualify as frustration of contract. And in those circumstances, the employees may be entitled to something. However, there may be other circumstances where frustration of contract can be established, and we will have to wait and see how courts decide these cases. For example, one may argue that a business being closed as a result of COVID-19 is an unforeseen event or circumstance that renders the contract impossible to be performed as originally agreed upon, and therefore frustration of contract. But we just don't know. What is the risk, though? Well, if an employer believes it is frustration of contract, but it isn't, then it is likely that that would be classified as a wrongful dismissal, and as a result, the employee would be entitled to their statutory termination pay, statutory severance pay, and common law notice. So, as it stands, we find ourselves in a wait-and-see situation as to how the courts will handle these circumstances and see whether or not it qualifies as frustration of contract. Thank you very much for joining me today. Stay well, stay safe, and please stay tuned for our next video. And please go to our website and sign up for our newsletter. Take care.